with us. So without taking much more time, should formally begin. Good afternoon, everyone. My name is Harsh Bedi. I am the founder of Mandate Project, and I would like to begin by thanking everyone for taking out time and joining us this Sunday afternoon. Please note that our session today is being recorded and shared on a live YouTube stream. As is customary, I'd like to begin by saying a few words about our organization. The Mandate Project aims to create a neutral platform that invites people from all walks of life, experts, professionals, academics, business, and the government, to come together, collaborate, and find solutions to the problems our society is facing today. It is our belief that complex issues will never be solved through isolated efforts, but through open and collaborative endeavors. It is this philosophy that motivates us. Though most of us are now grudgingly comfortable with virtual call etiquettes, I'd like to quickly go over some small housekeeping rules before we begin. All participants will be kept on mute while they're not speaking. Speakers will be able to unmute themselves. All participants are requested to keep their videos off during the discussion. Please use the chat box to share comments and questions during the discussion. Mr. Ritwick Dutta, Mr. R.N. Mehrotra, Dr. Narasimha Reddy, Dr. Lakshmanan, Ms. Jesu Rethanam, Ms. Prerna Bindra, Ms. Radhica Kanniganti, Mr. Abhiraj Naik, and Ms. Avastika Das. Thank you all for joining us today for the discussion. We have a diverse and accomplished panel of speakers with us. We're deeply grateful for your participation and look forward to diving into the discussion soon. Before we do that, allow me to briefly introduce each of our speakers. First, we have Mr. Ritwick Dutta. Ritwick Dutta is an environmental lawyer and founder of Legal Initiative for Forest and Environment, LIFE, a public interest environmental law group. He focuses exclusively on public interest environmental litigation and takes up litigation primarily before the National Green Tribunal on behalf of impacted communities and civil society groups. In addition to litigation, he is involved in capacity building, research, and policy advocacy on environmental law. He is an Ashoka Fellow and has authored books on environmental law. Next, we have Mr. R.N. Mehrotra. Mr. Mehrotra is the former head of Forest and Wildlife Department, Government of Rajasthan. He has 44 years of working knowledge in the field of core forestry, wildlife, watershed, biotechnology, and environment. He has headed the project for UN Habitat on restoration of the largest lake of Myanmar. He also successfully planned and implemented the long-term water sustainability of the World Heritage Site, the Bharatpur Bird Sanctuary, thus saving its deletion from the UNESCO list. We have with us Dr. Narasimha Reddy. Dr. Reddy has been a passionate campaigner on environmental and development issues. He has been campaigning on industrial pollution and environmentally destructive projects, including the latest Hyderabad Pharma City. He was a board member of IFOM Asia, member of a Cotton Advisory Board Committee, and Advisory Council of Textile Exchange, a global non-profit. He is also an author, writing on different subjects in regional, national, and international publications. We have with us Dr. L. Pushpa Kumar. Dr. Pushpa Kumar teaches at the Faculty of Law, University of Delhi. He is an interdisciplinary legal scholar who has contributed enormously to the field of environmental and biodiversity law. He has worked on several major studies for the Ministry of Environment, Forest and Climate Change, and the National Biodiversity Authority. At present, he is the member of a national level expert committee to review and propose amendments to the Biological Diversity Act 2002, its rules, and access and benefit sharing regulations. We also have with us Ms. Jesu Rethanam, who is the convener of Coastal Action Network, a campaign that works for the protection and promotion of coastal ecology and livelihood rights of coastal communities. She is also an executive committee member of National Fisherworks Forum, NFF, an active member of the Ocean Grabbing and Women Working Group of the World Forum of Fisher People. We also have with us Ms. Prerna S. Bindra. Ms. Prerna Bindra has been at the forefront of the battle to conserve India's wildlife for over a decade. She was a member of India's National Board for Wildlife and its core standing committee from 2010 to 2013. She is a widely published author with over 1,500 pieces on nature and wildlife, including her critically acclaimed book, The Vanishing, India's Wildlife Crisis, which was published by Penguin India, and a gorgeously illustrated book for children titled When I Grow Up, I Want to Be a Tiger. We also have with us Ms. Radhica Kanniganti. Ms. Kanniganti is an environmental and sustainability professional who formulated and implemented air pollution regulations during her time at the United States Environmental Protection Agency and the Ohio EPA. In India, she has worked extensively in urban and rural management. She is also the founder and editor of Capopseed, an online platform to showcase innovative technologies in the environment, in environmental sustainability. We also have Mr. Abhiraj Nayak, who is an advisor, consultant, and educator based in Bengaluru. He is the co-founder of a new non-profit organization, the Initiative for Climate Action, that provides transformative system change in response to the current climate crisis. He has been a consultant to the government of Karnataka on reviewing state-level environmental clearance systems, and is a co-author of the well-regarded Green Tapeism, a review of the EIA notification 2006. And finally, we have Ms. Astika Das. Ms. Astika Das is a student at the Faculty of Law, University of Delhi. She is also a part of the research team of the Mandate Project. She is interested in international relations and environmental law. To all of you, I extend a very warm welcome and thank you for taking time to speak with us here today. Before we dive into the discussion itself, I would request each of our speakers to give opening comments. And if it's all right, we would like to begin with Mr. Ritwick Dutta. Sir, the floor is yours.
So thank you for organizing this very, very important webinar. I think there's a lot going on, and I think what we must recognize is perhaps, let me change the word perhaps, and very clearly say that I think no environmental legislation has been subjected to so much of public debate and discussion as the EIA 22. You know, and despite the pandemic and others, I think the public concern has never been similar with any other legislation that we have. So I think this is something which is very positive thanks to technology. And despite the government actually going ahead, you know, with the draft and without, making it available in the local languages, which is the mandate of the High Court, I think the virtual medium has provided a platform for people to discuss about it. Having said that, let's, within my 5 minutes, I think what I wanted to explain is first and foremost, I'm fairly sure, that a legislation so poorly drafted will not be able to stand even a limited degree of judicial scrutiny. It's impossible, right? So you don't need an activist judge. You don't need an activist court. It is so poorly drafted. It is a legislation that has been drafted to fail. And that's what is the biggest concern. Because why would a government actually come out with a legislation which is completely against the Environmental Protection Act? Now, very importantly, let's look at it first, is that first and foremost, if you look at the mandate of the Ministry of Environment and Forest, it itself is to further the interest of conservation, protection, and animal welfare. That's what the Ministry of Environment says. There's not even one provision in this new EIA 2020 that furthers or strengthens conservation, protection, or the rights of the people. It is a legislation which has essentially been designed in order to facilitate and legitimize the violators. And that's where the concern comes in. Now, if you look at it, very recently, idly about 3 days back, the environment minister says, well, what is the main purpose of EIA 2020? He says the main purpose of EIA 2020 is actually to bring the violators, and bring them within the regulatory framework, to ensure that the violators that are there are brought to the book, that they cannot continue to violate. And therefore, this legislation is very, very important. The second point they say is that this legislation is important because it strengthens public participation, because in any case, public hearing is to take place only for 1 day, right? It doesn't go beyond 1 day. So therefore, in the second part also, they say it doesn't really, reduces the scope of, public consultation itself. Now let's examine it. First and foremost, this notification is not a parliamentary legislation. It is an exercise of a delegated one. So Parliament has delegated to the central government only one power, that is the power to take any such measures that are required in order to protect and improve the environment. That's it. It does not have. See, ultimately, this legislation is a creation of the bureaucrats and ultimately with the stamp and approval of the minister concerned. Does not have an approval of Parliament. The executive cannot go beyond the four corners of the statute. And if it is exercised under Section 3 of the Environment Protection Act, they cannot go beyond that. Second, the Water Act and the Air Act very clearly states that if any person, entity, or an industrial unit of any kind is operating without a consent to establish and consent to operate, it then constitutes a criminal offense. Very simple. And under the Air Act and Water Act, specifically the Air Act, if a person operates a unit without a consent under the Air Act, they are punishable for a term of imprisonment which cannot be less than 1.5 years. So Parliament has stated that this is the punishment that you have if you operate and establish without a consent to operate and consent to establish. The executive cannot then say that fine, the executive under his delegated powers cannot say, but in order to facilitate ease of doing business, so long as you pay 5,000 rupees per day for every day of violation, from the day that you violated the law until the day that you come and report to us, all your illegality will be justified. It is contrary to the powers that have been given to the central government. So unless there is a fundamental change or amendment in the provisions of the Air Act and Water Act, this EIA notification cannot stand even the first level of judicial scrutiny. It has to be struck down. And this has been what has happened even in the last 6 years. Every single amendment or notification by the government has been struck down by either the NGT or by the Supreme Court or by the High Court, principally because that power is not vested with the central government. So I'll just end here because I would say that this particular notification directly contradicts not just the Environment Protection Act, it also contradicts the Air Act and the Water Act. I'm not even touching the constitutional provisions. So therefore, if you look at Constitution, it opens up a huge lot of debate. But today, what it does entirely is turning every single office memorandum into a provision of law is what the central government is doing. It is contrary to every single judicial precedent that has been set by the court. It violates the NGT orders, and it also is violation of rule of law. Thank you.
Thank you very much, sir. Before moving to the next speaker, I would just like to recognize that Dr. Nagendran Murthy is also with us on this call. Welcome, sir. Thank you very much, Mr. Dutta. This was, I would like to come around after our speakers have spoken and ask a couple of questions on some of the issues that you raised also, if time permits. So next, Mr. Mehrotra, if you are able to hear us, sir, I would request you to speak next and give your opening comments.
Me, Harsh? Can you hear me?
We can hear you, sir. Please go ahead.
Thank you. Thank you. Let me start by saying good afternoon to every participant, and particularly the panelists who are here. It's very nice to have them here on a platform. And as Ritwick has already mentioned, I think the battle is, he's drawn the line very well. And because the move itself it is not standing on legal ground. Therefore, it has to be, it's bound to be struck down. But my issue is a little different. Why do all these things? I would like to point out, India has 4 kinds of important acts. One is your Forest Conservation Act, FCA. We have our Indian Forest Act, IFA. And then we have the Wildlife Protection Act. And the 4th is the Environmental Protection Act. Now, my question is that out of these 4 acts, these 3 acts, IFA, FCA, and the 3rd one, that is your Forest Conservation Act, they are all confined to the limits of the what you call the forest areas, except Wildlife Protection Act, which extends outside also. Environmental Protection Act is covering an area as per the legislation, which is in totality, the whole country is being covered by the act, but there is no one to really see that it is one of the weakest out of the four, and it has absolutely no godfather, no institutional backup, barring a few scientists sitting in the environmental ministry. There is no arm of this in the districts. The arm in the smallest district could be a district collector who will have it implemented through some agency, either forest department or through some kind of. So the problem starts from here. You are making a very wide kind of platform available to people who to set up their projects in this 80% of the area, which is outside the forest. Now, let us see what you will be doing. You will be touching upon ecosystems which could be extremely fragile outside the forest area. I'm again talking. The fragile systems which are at the lakes, the geologically sensitive areas, the river valley catchments, which may not necessarily be the forest areas, and then the continental shelves of all around our coast, parts of mangrove areas. So these are very, very fragile ecosystems that have been developed in a very long period of time. Now, by tampering with them, the project proponent would be doing simply an irreversible act on the, I think, to use a very harsh word, it would be doing an irreversible act on all of us, on the entire society, because I mean, it has gone too far now to see the way things are there actually on the ground. You take up any issue like mining of water or mining for ore, it is being blatantly done. I am being very frank on this issue. No one bothers whether it is a fragile area or whether it is a hotspot, whether it is harming a particular species, whether it is affecting the home of a particular microorganism. So these are things which are simply ignored across the table with a very harsh hand. So instead of doing all this, we should bring in something which is conservation based in the legislation, in what you call this kind of resolution. They have not bothered about what to introduce to improve the conservation of the environment. What they have brought in is to relax certain things which will harm the conservation efforts. So it is just the opposite that they are doing, for which the statute has been made. Now, I'll give you a very small example that they have given a 100-kilometer boundary, a peripheral strip on after the LCA, that is the what you call the LAC on the border of China and on the border of Pakistan, and LAC is essentially on the border of China. 100 kilometers will be an area that would not be requiring any EC, because defense projects that are going to come up there will be a free for all. The government will do anything. Now, if you close down on this strip, you will find very important areas of this country. The North Sikkim district, the Tawang, the Kamlang, there are 3 tiger reserves, Pake, Kamlang, and this Namdapa. All 3 tiger reserves, which are falling in this 100-kilometer line. Now, if you have been to that area, you would realize it's a very, very critical area, extremely fragile in the sense that you are having the only primate, number one, that is Hulog gibbon. The second is that you are having a juxtaposition of 2 systems, 2 ecosystems. One is your temperate and the rainforest. Nowhere in the world you will have a juxtaposition of 2 forest systems. Imagine the kind of organisms that are really evolving in such a climatic condition, in such a holistic kind of environment. So these are things which need to be carefully scoped. You don't, by just, you kind of steamroll the whole thing. No one watches it. Nobody examines all these aspects before sitting on the drawing board and preparing this. I would simply like to point out these things during the course of discussion. There are n number of examples in which I have seen during my entire career in various parts of the world. And I feel so sad when I say this, that humanity is really crushing everyone. It's crushing badly. You can't, no one bothers about these. You forget these 5 big mammals which we have in our country. Look down. Do you know how a gibbon cannot walk? It's a monkey which requires tall trees. And there is no mention of such kind of things in our acts and statutes. This is an animal which is extremely rare, and it is only found here. It is confined to a very small parts of Arunachal and Assam. Now it has no place to go. It can only survive on tall trees. Mehrotra trees, the tallest trees. Mehrotra is one of the oldest. I think it is coming from Miocene on some parts when the entire Himalayan valleys were covered with these kind of trees. They have all been cut back. The entire area of Arunachal has been already in 90s. All big old growth trees have been felled. That is how Central Empowered Committee was constituted by Supreme Court when these areas were being clear felled by the former Chief Minister of Arunachal Pradesh and his kith and kin. So these are things which need to be seen, and already it has been ransacked. What remains is to be conserved, is to be saved, it is to be protected through our acts. Our acts are contrary to this. Our acts are bring in more people, bring in more projects for more employment, and just steamroll it. So let us talk about it much later during the course of discussion. Thank you, Harsh.
Thank you so much, sir. Also, I have a proposition. Rather than moving mechanically through all our speakers and their opening comments, I'd also like to invite our speakers if they would like to comment on what any of the speakers have already said. For instance, if anybody would like to add anything to what Mr. Mehrotra has just said, we'd be very happy to hear from you. So to all our speakers, you can use the raise hand feature and I can invite you to speak, if that's all right. That way we'll have a little more of a lively dialogue between the panelists themselves. So, all right, if there are no comments, then we can, I'm sorry, did somebody want to say something?
I think, we can the first round, then that will be Harsh.
Sure, sir, we can do that.
Yeah.
All right, so Dr. Narasimha Reddy, sir, we would like to hear from you next. Thank you, Mr. Mehrotra, for your opening comments.
Thank you.
Dr. Reddy?
Yeah, thank you. I agree with the two previous speakers, what they mentioned. What I would like to add something more to that, especially when environment impact assessment came into India, we everywhere now people are talking of 2006. But I think the Environment Protection Act itself, when it came long back, and then the process of consent and the establishment began. So we were hopeful of something concrete happening. But if you look at in the last 15, 16 years, I think the EIA dilution started happening, even though we think some are very facilitative notification, but ultimately today, I think Ritwick Dutta can add also because he has that data. Today, every application before MOEF is almost cleared whether there are any objections or not. So ultimately, the current EIA process, I think it looks like more of a paperwork and a bureaucratic work. And secondly, we expected EIA to build a body of knowledge, at least on environment, ecology in India, but it did not happen. Even the expertise which should have which should have been built through EIA process is also not there. So the entire educational system, universities, research systems, they're all outside the EIA process. So that's why we currently don't have a body of knowledge. And 30 years back, when we wrote a status of and data, and only civil society had that data. And today also we are looking at status of forest report, and no other report we have, and which is updated and which has some integrity in that. Now, having said that, I think the current EIA 2020, I feel it's being used as a tail to wag the dog. So Environment Protection Act itself is under danger because of this EIA 2020. Now, I'm not going into details in the EIA 2020, but I would like to zoom out and look at what are the problems which we are facing and why EIA does not respond to that. You know, I'm working on national fiber policy. I do work on electricity issues also, and also GM crops in agriculture. So these are all public policies which are having a huge potential of impact on environment. And we don't have any legal process which we can assess the impact of such policies. So national fiber policy where textile industry, is going to introduce more and more man-made fiber rather than, natural fiber and handmade textile production. I think this is this does not come in, and we are helpless and how to tackle that. And EIA 2020, of course, it talks of only projects, and those projects also, I'm amazed that one of the definitions of the projects is any activity, and then they give exceptions to those activities like sand mining in various places, even by farmers, by gram panchayats. I think those exceptions, at least 18 to 28 exceptions are given under that project. So EIA 2020 is trying to limit EIA only to projects and then not looking at the public policies as well. And I feel civil society has also failed somewhere in countering this ease of doing business through which, without any legislation, through only an operating manual, they are able to overcome the legal provisions available under EIA or the entire environmental legal framework. I think this has not been countered enough. So whenever we are discussing EIA 2020, I think we need to look at that as well. And one small question to every one of us is, even in EIA 2020, whether EIA report is a legal document. Now that we are, it should have been done earlier, because when you are looking at lies, blatant lies coming out of the document based on which we are, impacting the environment and future generations, there is a liability built into that process. So even if we would redefine consultants as ACOs or whatever in the EIA 2020, but the liability, I think, has to be built. Unless that is done, that has to be criminal liability, because a decision taken based on this false or lie, report which is full of lies, I think it impacts many lives. So that liability has to be asked. Now I'll have two more points, and then I'll stop my remarks. One is, I think, the institutional spaces within the EIA process earlier and also in the current proposal, they are all they are not being interdisciplinary. Even though we have committees supposed to be interdisciplinary, we don't get enough people, expertise to do that. And even if they are done, it's only a part-time work for them. And then this national, state level and district environment impact assessment committees which are proposed, I think they are all looking at administrative boundaries rather than looking at the ecology and environment in the larger picture. So even when we are discussing a river, I think unless we have a river basin as an approach, and if you just look at a district and then the impact caused by certain project on that, I think we will be losing the big picture there. So we need to look at, relook at these institutional places, spaces, and how they are monolithic rather than participatory and interdisciplinary. Finally, I think we have to, though a lot of criticism is being done on EIA 2020, I think it's time, as Ritwick said, now there's a lot of focus, attention, especially from youngsters. I think even students are coming in and they are all contributing to this discussion. We should prepare an alternative draft. I think the draft, which includes basically operationalizing the precautionary principle, and then it should include 4 important things. One, it should include policies as well, public policies which have potential to impact on the environment and ecology. And 2, this draft should transcend administrative boundaries, because currently the politics which are being played by the state and within the national level, within the political parties, I think we need to transcend that through going above the administrative boundaries. And 3, I think we should ask for preemptive annual status reports on all natural resources. We need annual status reports on water. We need annual status reports on forests, so on soil. So I think every natural resource which we think is going to be impacted, there should be a status report, and that should be mandatory as part of the Indian Statistical Act or whatever legislations we can look at. Finally, I think the land use policy. Without land use policy, I think the environment impact assessment, even the clearance process is not complete, because the committees are also sometimes hopeless because they don't understand the land on which certain projects are coming. So we need a land use policy. And finally, EIA is a subordinate, even if it is a subordinate legislation, I think we need to back it up with a comprehensive environmental policy. We have very good Environment Protection Act, Water Act, Air Act, and of course for Forest Acts, Wildlife Act, everything. But there's no policy which can set the direction for all these legislations to be operationalized. So I close my remarks here, and we'll have discussion. Thank you.
Thank you very much for that, Dr. Reddy. We'd love to come back to some of the things that you said, especially about developing a comprehensive policy, role of an independent agency, and I'd like to pose that question later to our other speakers also. But in the interest of time, I'll move on to our next speaker to give his opening remarks. So Dr. Pushpa Kumar, sir, if you're there, I request you to take over.
Yes, I'm here.
Yes, please go ahead, sir.
Hello. Yeah. Very good afternoon to all the speakers and participants. I'm really surprised this draft notification. The country that been consciously trying to strengthen the EIA process, even though both the 94 notification as well as the 2006 notification have not really tries to fulfill the real objectives or to bring the real sanctity to the EIA process. In the course of time, the Supreme Court, as the high courts, the National Green Tribunal, they have intervened and they have really come out with wonderful suggestions, judgments where they have enshrined the principles, insisted that, how the EIA has to be operated in the country.
Lost all interest.
Despite all this, that, we have a surprising, here that tries to negate all this good efforts. So that's what, I'm going to throw light on the very necessity of having a sound EIA process. And this I would like to link with international law and the help of the strict laws we have here. India is not the only country that implements EIA. It's implemented all over the world. Every country has the system of assessing the prior assessment of any developmental project before it being approved, and they try to bring a kind of harmony between the development and environmental process. International law organizes it. Start from the Stockholm Declaration, Rio Declaration, 2017, where clearly says countries have to the importance to EIA, and if there is a danger of environment getting affected or irreparable damage being caused due to any developmental project, then EIA has to be considered as an effective tool. And not only principles in international law, the International Court of Justice also recognizes. So just like Pulp case, the Govt case, these are the cases where they have given the importance, and they have also recognized and applied the EIA at the national level. India comes to, when we come to India, we have adopted all these principles, all these, international instruments that have adopted. We have always engaged into the international process, and we have ratified, and we are implementing in India. And it appears here. Two important objectives of EIA is, one is implement precautionary principle. The other one is the larger objective of achieve sustainable development. And both can be possible with the first step of doing it. So before any project comes, we need to understand what are ramifications of project and what kind of a safeguards we need to. So that can be possible only when we study the impact of a project. That's what this is precautionary measures of all. And while doing so, we understand the pros and cons, and we try to negotiate how much we allow and how much we can what of a safeguard can take. That only facilitates sustainable development. And this particular draft goes against both principles, the cautionary principle and sustainable development. Okay. And I would like to explain with the help of four important things that coming out of the draft. One is this draft facilitates the ex post facto approval for the projects which have started without getting prior environmental clearance. So that is really surprising. So how can you do it? That is number one. There is another provision which says that in the public hearing is limited, and public hearing, the scope of public hearing is restricted. For most of the process, it has been taken altogether. The third aspect is that every environment law, whenever there is danger that the an entry has function without proper clearance or approval, whether it is Water Act, Air or Environment Protection Act, every law provides the power to the common man, the citizen, to raise it to the appropriate forum that this is the problem that we need to some kind of action, and that complete scope has been taken in this draft. So whenever there is a violation case, it's only the industrial proponent or the appraisal committee or the government authorities, they can bring it to the notice of the authority, and then they take actions. The public's role is completely limited. These are certain points that we need to really worry about in this draft notification. And particularly if I have to explain the ex post facto approval, this has been time again negated by the Supreme Court as well as by the National Green Tribunal in different cases. For example, in Society for Protection of Environment and Biodiversity versus Union of India in 2017, the court has very clearly stated that this kind of the ex post facto approvals should not be allowed. The case called the common cause and the Alembic pharmaceuticals case, where Justice Chandra, the Supreme Court, very clearly stated that this goes against the environmental jurisprudence itself. If I have to read one line, it says that the content of ex post facto environmental clearance is in derogation of fundamental principles of environmental jurisprudence, and this is an anathema to EIA notification. After doing all this, after having such an elaborate environmental jurisprudence country, still we are trying to completely demolish whatever we have built up over the years. That is what I think we need to really worry about. There are other points I can do that at this point I leave here, and time of a discussion I would like to elaborate if any questions posed on this. Thank you very much.
Thank you very much, sir. Thank you for shedding light on the philosophy of EIA and what its intended purpose is. And we will of course circle back to this once we've heard from the other speakers as well. And so I would now invite Ms. Jesu Rathinam. Ma'am, are you there? Are you able to hear us?
Yes, I am there. Yes, I am there. Yes, I am able to hear you. Yeah.
Right, ma'am. Welcome, and please go ahead with your opening comments, ma'am.
Yeah. Thank you for giving a chance to share the struggles and other things, how we used EIA. Here, actually, as the previous speakers and the earlier sessions had gone into the details of EIA 2020, draft EIA 2020, and why it needs to be defeated or to be withdrawn. So now, here I would like to share our experience as Coastal Action Network, how we have used EIA in fighting different cases and challenging the environmental clearances given by the EAC. Now, if 2020 comes into existence, what will happen? So that is the angle which I would like to share in the time given for me. So EIA, as everyone has stated, EIA is a subordinate law, and so it doesn't need any to be placed in the parliament. All those I agree with, and this EIA, now when it was in 1994, from even in 1997 when the public hearing notification came, and we have used all those things, all those notifications in fighting the rights of the communities and fighting to protect the environment and also coastal ecology and the livelihood rights of the communities. So now I would like to share, as you all have stated, everyone has stated about the precautionary prevention and public participation polluter pays principle. Environmental principles are in this EIA notification and law is based on this principle, and it has a procedure of scope when a EIA process is happening, environmental assessment process. It goes into 6 processes and steps, and we have intervened many times. We always, as a community organization, we intervene only after the EIA studies are over and it comes for public hearing. And the earlier processes, yes, we can do something, but we have many times the CSOs, civil society organizations, fail to do that. So, for example, I can say that the day when they come to purchase lands in the communities, the community know that some project is coming, but they remain silent and allow the lands to be purchased. And when they purchase lands, the industries, it's large stretches of lands, or some are private, and it includes large stretches of government lands, channels, irrigation channels, everything. I would like to state only one example here. With that, I would like to explain how we have done. So here, it was in Nagapattinam district is a delta region of Kaveri, and it has nearly 100 kilometer stretch, and within this 100 kilometers of stretch, the proposed power plants were nearly 11 and almost 11 power projects, coal-fired thermal power projects. And it that means this 100 kilometer, every 10 kilometer will have a power project. And the power, they were of 662 megawatt production. And so if you go into the land purchase, it went up to 750 acres, 500,000 acres. And now these lands were bought from the year 2000 yards itself. It started, and they did the EIA, and the EIA also was submitted to the Environmental Appraisal Committee for clearance. And in this, I'm not naming all the power projects, but there were 11. Now, we fought against every public hearing. Community organizations came in large number and expressed their views against the power project coming in. The thing is that when it came for clearances, and we fought when the clearance was given to Chettinad power project in Nagapattinam district. An appeal was filed against the clearance in the National Green Tribunal, and the National Green Tribunal ordered to have a impact assessment study, that is cumulative impact, because 11 power projects, it cannot be considered as in isolation. That was the argument what we placed, and court also agreed and told that it should be done. When after that, it was a partially in favor of the communities for and partially it was not in favor. So we went for appeal, taking the negative factors whatever there in the judgment. So when we went for appeal, again, after hearing 1.5 years, the Justice Chokalingam, who was heading then the Chennai NGT Tribunal, he withdrew himself, stating that he is very close to Chettinad power project. And so we had to go to New Delhi, and it went on. And every time the court also ordered to do additional reports, because we challenged the entire EIA report itself. And so when it came for, when we challenged that, by the time it became 5 years, so they had to apply for renewal. When Chettinad applied for renewal, we argued, we placed our argument before EAC, stating that this original EIA doesn't have any value after 5 years. They have not yet started the power project. So how can they go again with this EIA to a renewal process? And we placed all our arguments before this, and the EAC also rejected their renewal, but they went in appeal for the Supreme Court. By the time the renewal, the EAC, the environmental clearance expired. So they were not able to do, and it was before the Supreme Court, and they also uphold the rejection order by the EAC. Now, without clearance and without doing a fresh EIA, they are now not able to start the project. These were all possible because public participation was there in the original notification of 2006, and also now without clearance, a project cannot be started. That means now, if 2020 comes, if the post facto clearance is allowed, then there are nearly 11 power projects which the lands have been bought and lying vacant because they are not able to start the project. They were waiting for Chettinad power plant's judgment and waiting what it was. If it was in favor of Chettinad, all the power projects would have gone for the next process. So now, and the lands are lying vacant, and most of the things they are trying to sell it to the now hydrocarbon project which is coming there, proposed there. So now, to if 2020 paves way for not public to be heard and bypass of public hearings in many cases, and then exemption to the projects also, then exemption to oil, offshore and gas exploration projects. And so this, if 2020 comes into a reality, then we will be really, and we have not only used EIA also, the NGT also, but we have used the Water and Air Act also, where the consent to establish was not given. So when the consent to establish was not given, we filed a case. When it was given, we filed a case and we told them that consent established cannot be given because most of the irrigation channels are taken by the Chettinad, nearly 450 small channels and 45 big channels were taken of the Kaveri Delta region. When we mapped and produced evidence, even the consent to establish case is pending before the SEIA. So this fighting against these things in different forums and different ways, and trying to take it every step forward. Till now, these power plants are not able to establish themselves. Once 2020 comes, becomes a reality, or it is past, if you don't defeat it, then all the projects will start without any clearance processes. And last, to add to what I wanted to end up with, this is totally against our constitutional rights guaranteed under Article 21 and 48A and 51 AG. So all these rights ensures that protection of life and personal liberty. It's not just a right to life, includes to have a healthy environment also. So when it is against our constitutional right and right to expression, when the public hearing process are stopped, or it gives exemption to public hearing process, then our right to expression is also challenged and it is questioned. So it is against our constitution and all the many verdicts of the Supreme Court judges and verdicts of different courts. So this has to be defeated. From our experience, if it comes into a reality, the community and the civil society organization will not have a space as we had, the minimum space we had. I am not saying we had the fullest space in 2006. There also we had a lot of issues. But the space we had will not be there if 2020 comes into extension, and all the lands will be in the big business people and the corporates, and they are the corporate want the lands. Now, to say in 2020, the sea, that is the territorial waters of the coast, is also included. That means up to 12 nautical miles come into there. The projects which comes there also are included. And never only the, if including, and then where will the fishing communities, especially, that is the space for fishing. And that is the fishing area. All the industries and industry projects promoted in the name of Sagarmala and blue economy coming into the sea means, and without any clearance means, it is the end of the livelihood. It challenges and it affects the livelihood rights of the communities also. So it is a thing which is against the constitution, which needs to be defeated. Thank you.
Thank you. Thank you very much, ma'am, for explaining how the EIA can be used to protect the rights of communities and how this can be used in action. So we will move on to our next speaker, Ms. Prerna Bindra, if you're able to hear me. Yes, please go ahead. We'd love to hear from you.
Thanks for this opportunity, and it's been terrific to listen to all my predecessors. And so I will focus on the first thing on the impacts on biodiversity and wildlife. But first I would like to say that I tried really hard to find what is in this piece of legislation, proposed legislation, that is for the environment. And if anybody can help me in that, I'll be grateful. So, this does not, it's not an amendment. It fundamentally changes the nature of the EIA. It's to one that is mandated to protect the environment. I mean, I'm not saying the last one, what we had till now, is perfect, but at least there was that fig leaf that there were provisions. And as Jesu Retinaman ma'am showed us, it has helped in stopping damaging projects. But this one, by its sweeping changes that it has wrought, like for example, it reduces the rigor and the number of oversights. It has shrunk the space for public speaking. It has shrunk the space public hearings. So that's violating, and they're not in the spirit of democracy. It has reclassified industries into what is the B2 category, and which completely, once when you're in this B2 category, it means you don't need any environment appraisal, you don't need any public hearing. And these include, so the industries in these now are potentially very damaging. I'll just pick up one, which is national highways and state highways. And since I'm focusing on wildlife and biodiversity, we know linear projects like highways, canals, railway projects. Railway has never found a mention in EIA for some weird reason, though their impact, if we just look at the Hubli-Ankola project, which is going to take about over 650 hectares of forest, cut into pristine Western Ghats, which has tigers, elephants, many endemic amphibian species, etc., but no EIA. So highways now will also be exempt, and highways, such linear infrastructure, go into one of our most biodiverse forests. Tiger habitats, elephant habitats, and their expansion is not going to require any environment impact assessment. So to me, that is very, very worrying. And also it legitimizes violations by the fact of de facto clearance. Sorry for that. And so we know what is the, something like a polymer, the algae polymers case. That is a perfect example of how these normalizing such violations, the post facto, you can violate as you will, and later by just paying a fine, you can continue your damaging, polluting activities. And that resulted in the death of people. It has caused untold suffering. It has resulted in economic losses. And how do you monetize what the impact will be on wildlife? How do you monetize what will be the impact on fragile ecosystems? You allow something like oil exploration, oil drilling, or say we are seeing what is happening in Bagjan in the Dibru-Saikhowa Biosphere Reserve in Assam. It's 40 days on or maybe more, and we're still not able to put out the fire. The entire fragile ecosystem, the wetlands, which communities were dependent on, which is home to many critically endangered species, endemic species, is still on fire. The losses are irrevocable. Billions of dollars and rupees, and many decades later, we don't know whether we'll ever be able to get that back. That level of environment, that health, the ecology, will we be able to get that back? So this is a Pandora's box that we are, and many of these B2 projects are in ecologically fragile areas. They could be grasslands, wastelands, and Ramesh Mehrotra sir did speak on it. But I would like to emphasize on wildlife outside protected areas. So we know for a fact that at least a third of tiger population, 2/3 of our elephant population are outside protected areas. Much of our, and a lot of other species, rare endangered species, from wolf to fox to great Indian bustard, and you can just keep going on. And there is not even a, this will be further endangered, because now you can just start your projects, because these 40 odd industries, including national highways and state highways, ropeways, they're all excluded from any kind of environment appraisal. And so you also have a ropeway. Now a ropeway might look very benign, but ropeways drill into mountains, including habitats of critically endangered vultures. You need roads for them, they dig the earth. So where is the impact assessment for this? Who is accounting for the losses? And one last point that I would like to make, the other thing is that it also allows for leveling of land. So without any tree felling. Now, how do you level land without tree felling? Okay, by some miracle you manage it. This is likely to be in a wetland, grassland ecosystem, which are the most productive ecosystems. Grasslands, we deem them as wastelands, but that is again home to a number of endangered species. Plus, this is what our livestock feeds on. So to my mind, the losses to, it has not, it's actually the environment impact assessment process has never in its loop considered the impacts on biodiversity or wildlife. It has never been an important factor in its weightage. And EAC, the Environment Appraisal Committee, really has representation of wildlife and even expertise in it, even though a lot of these EIA, the projects which go for an EIA, which need an EIA or don't as per now, are in many ecologically fragile areas. So this is a lacunae that has not been addressed, and in fact, we are just downhill. Last point is that it only considers in passing the notified ecological sensitive zones, eco-sensitive zone. Only the government, the notified eco-sensitive zones. While we have a number of eco-sensitive zones like important bird areas, we have wetlands which are under the Wetland Regulatory Act rules. We have mangroves. So where is the environment, biodiversity, wildlife assessment for those? How do you just allow a project without? So I think the losses, if this were to go through, will be irrevocable. The damages will be irrevocable. We are seeing even as we speak, the fire continues. And so we cannot afford to let the CIA draft notification pass if we want to conserve our wildlife. And I would again emphasize what Jesu Rethinam said, that this is against our constitution. It is against its parent legislation. It does not follow its parent legislation of the Environment Protection Act. It's the spirit of democracy without, as it shrinks the space for public hearing. It does not adhere to various international commitments as far as conservation is concerned. So in one shot, this thing, I think we need to scrap this, withdraw this, and strengthen the existing notification. Strengthen not just in letter, but also in its implementation. Thank you so much.
Thank you so much. I'm going to move, thank you so much for your comments. I'm going to move quickly to our next speaker just so that we have a little bit of time left for, we have certain other speakers who have also, participants who have joined us, who we would like to hear from. But let's we'll just move quickly to our next speaker. Ms. Radhica Kanniganti, are you able to hear us?
Yes, thank you. Thank you for having me here, and it's been such a pleasure to hear all of you speak, and you pretty much covered everything that I wanted to talk about, but I'll just keep my opening comments really brief. I think, like, all of you have spoken about, just the whole, the inadequacy of the EIA. I would just like to, look back into this. What is the intent? The intent of the EIA, as it mentioned, is, it's good. In the sense it talks about, looking at the environmental impacts of any project. And if you look at how the EIA is structured in principle, it covers, it gives a clear and comprehensive outline on the requirements, and for the most part follows the same format that is followed internationally. Secondly, it is designed to feed into the permit system pretty seamlessly, like in the consent to establish. That's how it has been designed. So in principle, the system seems pretty good. But when you go deep into and look at it more closely, and you start seeing the differences, having worked in the US EPA in the permitting division, you just start looking at all the differences that are there. And I'm just going to highlight a few of them, which I think have already been talked about, but just like to cover a few more points. First, you look at the applicability. Who is required to get an EIA? And more importantly, who is exempt? This is such a wide, it just leaves everything so open. For example, the 2006 notification itself put the onus on the State Expert Appraisal Committee to decide on which categories are exempt. And now, the 2020 notification has actually spelled it out. And my question is, has the cost to the environment been calculated and taken into account while deciding to omit these categories from getting an EIA? So has there been a detailed data analysis on this? And second, thing I would like to bring out is, of course, public participation. And I think all of our experts on the panel have been talking about this, and the importance of this cannot be stressed enough. The citizens have not only the right, but also the responsibility to participate and have a say in the project that directly impacts them, as Ms. Jesuratnam has, so correctly pointed out. I mean, without public participation, there's so much could have been lost. So ideally, an EIA process should invite the public to participate in 4 stages. Yet our process that we have, as it is, invites public participation only towards the end. And so we have been poor at this, even with the existing notification. Even then, the 2020 has further diluted this process, right? I mean, by exempting several categories from public participation, that the public doesn't even have a chance to look at what's happening. Typically, in the US, for example, an agency has to put out a notice of intent in the Federal Register informing the public of upcoming activities. So the public has a chance right from the beginning to participate in the EIA process, and that is completely lacking over here. The last point I would like to bring out is the EIA preparation itself. As Dr. Reddy pointed out, I mean, where is the independent third-party analysis on the EIA? The company hiring a consultant to prepare the EIA is in itself an opportunity for a conflict of interest. So while the process calls for a review with an expert advisory committee, do we have an interdisciplinary committee with adequate capacity to review it? Very doubtful. And decision is mostly based on what the information is provided by the client and the consultant. So how effective is the EIA really in serving its purpose? Is it just another paperwork? And that's something that we need to look at. So, and lastly, we need data. I think there is this complete lack of data in our system. So we need to look at what the ecosystem impairments are, assess these from time to time, and compare them. And every kind of notification that is out there has to make an assessment on what impact that notification has on these impairments. And I think that process is completely lacking. So, and I would agree with the panel to say that we really need to strengthen what we have, need to re-look at the EIA notification comprehensively to make it more effective. And with that, I would leave the floor.
Thank you very much. But if time permits, we'd happily come back to some of the points that you raised, especially about data and about the need for an independent agency, because I think it will circle back to these questions in a bit. We have 2 panelists left. We have Mr. Abhiraj Naik. If you're able to hear us, please go ahead, unmute yourself and speak, sir.
Good evening. Thank you to the Mandate Project, to Mr. Harsh Bedi and Dr. Pushpa Kumar for organizing this really important consultation. So with the permission of my esteemed and learned co-panelists and also colleagues and friends on this call, I would like to, without repeating what has been said so far, all of which I endorse, direct my comments to the question of how does one adopt a perspective to evaluate something like the EIA 2020 in light of India's own history with environmental regulation and in light of what scholarly and synthesized insights from empirical studies have told us, right? And just that perspective is what I'm hoping to bring to this consultation. With your permission, I'm going to share my screen here. And while I will not be able to, of course, go through these slides in great detail, I'll be happy to share with the organizers, to share with everybody else who's interested. Now, the first point that I want to make is that something like environmental performance, which at the end of the day, be it on biodiversity or community well-being or the monkeys that only live in the tall trees we are all interested in, is a complex factor of not just something like the EIA, which might be part of your environmentally environmental regulatory regime on the top right, but also the larger economic and legal context, right? So your civil liberties, your property rights, your level of administrative corruption, honoring of policies through government, along with science and technical infrastructure are equally important, right? So stringency of standards and information regulatory structure enforcement we're talking about. But let's also talk about these bigger factors that are inextricably entangled with environmental performance. Second, I've seen in the chat some comments on why is EIA important, and at some level, the value of such a question is EIA by itself is not the be all and end all, right? So the EIA works with existing Supreme Court law, even environmental crime law that has a place in Indian environmental jurisprudence, along with the broad catena of national, regional, and international law and market-based instruments. And scholars such as Professor Faure from the Maastricht University have pointed out that you have to see how one policy integrates with the other. And no matter what policy or regulation you're looking at, it's useless to talk unless you are also talking about enforcement and monitoring, right? Professor Christopher Wood is the gold standard when it comes to actually crystallizing the criteria by which you can evaluate an environmental regulatory system. He's based at the University of Manchester. I can't go through all these points, but I'll just direct you to point 7 there. Must EIA reports be publicly reviewed and the proponent respond to the points raised? Or point number 8, must the final decision actually be centrally based on the EIA report? Or point number 14 that Dr. Reddy alluded to, does the EIA system also apply to programs, plans, and policies apart from projects, right? And this is one way in which we can systematize the wealth of all our objections to the EIA 2020 draft. Of course, scholars have done this for India as well, using Christopher Wood's framework. I just point you to a 2012 piece by Panigrahi and Amirapu, which me along with Bangalore-based colleagues relied upon to evaluate the environment clearance system in Karnataka in 2014. So I'm winding up now. I think one big lesson to be learned is from the European Union process when it came to reviewing and amending the EIA directive of 2010. And take note, that process took 4 years. For someone like Prerna who was asking, where do I find the biodiversity information? It's not like the regulator just vomited some kind of complicated draft for people to do what they wanted to. There was a nuanced, detailed questionnaire that actually asked people specific questions on specific elements within the draft or within the process. It was available in all languages of the European Union. All of the responses were made publicly available, were analyzed. The main inputs from the responses were also made publicly available, along with position papers submitted. And a follow-up sort of focused consultation with 200 stakeholders was organized. So between 2010 to 2014, when there was finally a review, all of this happened, which actually made it a transparent, participatory, and robust process. So in my opinion, like many colleagues have stated, it is incredibly poorly designed, the 2020 draft. It's reductionist, it's misguided, it's unscientific, it's anti-democratic, and is downright illegal, as Mr. Dutta pointed out, and others as well. Going forward, the draft must be scrapped. A truly participatory, long-term, and just process that goes to the most vulnerable must be institutionalized, and immediately existing flaws in the system must be remedied. My one concern, and this is my ending note, is that I'm worried that from the history of the EIA in India all the way to the Silent Valley and the hazardous waste rules where it first made its appearance in Indian law, to 2020, suddenly a lot of attention is being focused on this demon, the 2020 draft. And my own wish is that the entire rotten system of environmental regulation, both the Supreme Court and the CAG have pointed out that our system is rotten to the core. I think all of that needs to be pulled out by the root and something that's healthy and non-toxic planted in its place. So thank you for your attention, and I'll stop my screen share now.
That was very comprehensive, and I'm going to have to ask you if you agree to please share your presentation so that everyone can have a look at leisure. Perfect. Thank you. Thank you so much. And we move quickly to our last speaker now. We have Ms. Ostika Das. Ostika, if you're there, please unmute yourself.
Ostika is the student representative, youth representative for us. Yes.
Ostika, are you there?
Yes. Hello, am I audible?
We can hear you. Yes. Please go ahead.
Yes, I guess I'm here for the youth quota. Not to suggest that the speakers who spoke before me, all esteemed luminaries, were anything but useful. So my name is Ostika Das. I am currently studying law at the University of Delhi, Faculty of Law. And I have been involved with the mandate project in the consultation, EIA consultation program. So some of the, to quickly recap what most of the speakers have already touched upon and what we have also encountered in the course of our research is the major problems or the fault lines and fractures with this policy proposal are, number one, you have the ex post facto clearance, which essentially mean that in order to bring violators into the fold of environmental regulations, projects that have started without obtaining such clearances will be allowed to operate after paying a certain degree of fine. And this, as many speakers have already pointed out, will surely institutionalize and incentivize the psychology of non-compliance. Number two is the reduction in the scope and importance of the public consultation process, which is the central cog of this entire architecture. The third is how exclusionary the draft notification is in terms of in the way that it excludes linguistic, ethnic, vulnerable communities. It isn't being translated. There is no provision to translate the environmental impact assessments into enough regional languages or dialects, and that goes against the pluralistic nature of our democracy. And lastly, the greatest problem with the environmental impact assessment notification is not the categories that have been included within the draft, but the ones that have been exempted. As many speakers have already pointed out, the exemptions, the categories of exemptions will spell trouble because these will have far-reaching consequences for our environment and ecology. So the crux of the matter is that this document fails to internalize external costs. And that is where I believe the youth come in. Whether it's Greta Thunberg or our own Lichipriya Kangujam from Manipur, the youth have been increasingly involved in climate activism and movements. And they have come out in large numbers to right historical wrongs. And we have this incredible power. So we need to, one of the things that I want to speak about is how we need to locate this draft notification within the broader picture, where there is a climate of censorship, where organizations and websites like Fridays for Future have been allegedly blocked by the government, where not enough dissent is being allowed to thrive. And I've studied in Jadavpur University and then subsequently in Delhi University, both institutions that have a very robust culture of protest, student protests, which only fortify my belief that these institutions, students are the seat of dissent. And the key element of a thriving democracy is this dissent. So that is the one thing that we must seek to protect, we must seek to preserve. Now, my advice in my limited experience to everybody who's listening on is, what can we do? We often, in the face of such seemingly insurmountable challenges, we often ask ourselves that, are we too small to make change happen? And my answer to that is no. No one is too insignificant to impact change. All you need to do is, you need to write an email to the Ministry of Environment, Forests and Climate Change, telling them why this draft notification is appalling, why it goes against all the principles of environmental jurisprudence, and why it must be repealed at the earliest. And arguably, we as a youth have the greatest stake in this. Therefore, we must act because we will inherit the world that is left behind. Therefore, we have the greatest stake in stopping such unconscionable developmental agenda. And with that, I would like to end my speech. Thank you.
Thank you so much, Astika. You said youth quota, but I think the youth quota is actually the larger part of at least the population of our country. And the whole idea is that we've got this distinguished panel of experts. We have, what was heartening to see is that several of the experts are already well acquainted with each other. Our desire here by bringing everyone together is to also bring the youth and bring other people who may not be in the know about the EIA and its problems into the broader conversation, because it does concern everyone. And so with that, I want to thank everyone for the opening comments. I'm painfully aware that we're close to the end of time. I would like to have the panelists, perhaps if they have any questions towards one another, if they would like to ask anything or make any comments, I would invite that. But just before doing that, because this has been a common thread, and there are a lot of lawyers here, but I'm not sure if some of us are. So for the benefit of some of the students who have joined us, I want to just put a little bit of focus on the aspect of subordinate legislation, which started with the opening remarks that were given by Mr. Dutta. So I would, sir, if you're there, I would pose this question to you and just follow along the lines that you had, the outlines that you had given for the EIA and why it's a problematic piece of subordinate legislation. So just picking up where you left off, you said that the draft EIA notification is a piece of subordinate legislation which is not passed by the legislature. And as such, it must operate within the framework that is set by the parent legislation, which is the Environment Protection Act, 1986. The spirit of the act is to protect and improve the environment. Most of the provisions, as all of our esteemed panelists have pointed out, seem to go against that spirit. They also seem to go against important judicial pronouncements which have established certain environmental principles. So if the notification is passed in its present form, can it be challenged in court? Also, since Astika spoke about some of the youth organizations, for instance, what happened with Fridays for Future, what is the room that is available for the youth or for people to discuss this openly, freely, without fear? Because it is an important piece of regulation that will come into effect. So to Mr. Dutta, sir, if you're there, we would like to hear your views on this.
Yeah, thank you.
So you're muted. You've got on mute.
Yeah, to your questions that there, the question is not whether it will be challenged. It is bound to be challenged. And if you look at it here, earlier, every single amendment that they did, if you recollect, just about, 2 years back, they amended the EIA notification to exclude building and construction activity from the purview of EIA. It's something that was challenged. There was no social media campaign. There was hardly even a voice from the civil society group, including environmental NGOs. But it was challenged before the NGT and it was struck down. Why? First, because of the principle of non-regression, right? That you cannot take, as the crisis on environment is becoming more and more severe, you cannot put, environment in a lower pedestal. That's number one. Number two, there the predominant idea is ease of doing business. Here also the minister is on record saying it will facilitate ease of doing business. That's a constitutional issue. I will not say it's an administrative issue. It's a constitutional issue, right? Is Article 21 subordinate to ease of doing business? The third that they usually used at that time is, well, it is supposed to provide housing for all. So if you exclude building and construction, it will lead to speedy construction of houses. When we went and challenged it in the Supreme Court, we used one very simple idea that is called, hiding behind the poor. Don't hide behind the poor. And that's what exactly was done, because we showed up one very simple thing to the court, right? That not a single housing for poor people require an EIA, right? It is all those 6-5 bedroom, luxury flats which are more than 20,000 square meter. Indra Awas Yojana is about 30 square meter, right? You don't need 20,000 square meter for a Indra Awas Yojana. So therefore, what is today been done is to give an idea that if you have this law, everything will change and the country will suddenly become the next USA or China. That's not going to happen. And also, I think what is also very important to realize is that, I am little, I'm still at a loss to understand that, when every single project under the existing regime is approved, right, then why do you need to relax it further? Look at the, we just came out with a, performance of last 1 year. And what we found, not a single forest clearance denied, not a single environmental clearance denied, not a single, wildlife clearance denied. Anybody who wants to do anything in this country, the only ministry that allows, red carpet treatment, is the Environment Ministry. That is why, what is it that they've said before the Delhi High Court? That, it is wrong to say that the Ministry of Environment did not reach out to the people of the country to explain about the new draft. We wrote, by we means the Environment Ministry, individually wrote 78,000 emails to all industries asking for their comments on the EIA notification. And the same ministry says, well, we don't have time to send it to panchayats, right? We don't have, now they have challenged it before the Supreme Court, stating that if you have the new law and the direction of the Delhi High Court, put in place, you will have an anomalous situation where every law has to be translated into a local language. It will create a problem. So, which is very odd, because if you have something that affects the life and livelihood of the people, you do need to have it in the local language. If you bring an amendment to the Companies Act, right, or Telecom Act, you don't need to bring it to every language. But definitely a forest and environmental law has to be treated different from an amendment in the company's law. And finally, I think one of the very important point that I think, will have to be taken into consideration is, well, India is bound under Article 253 to comply with international commitment. If you today do away with public hearing, if you do away with public consultation, that will be directly contrary to India's commitment under Principle 10 of Rio. Right? It is very important. One, it would directly contradict it. So there are various grounds of constitutional challenge. There are real grounds of it. And I'm very sure that the government really may have been shocked, because just look at the amount of challenge that is happening only on the issue of time period for comments. You have a Madras High Court, you have a Karnataka High Court, and you have Delhi High Court, 3 High Court. Think of what will happen when they come out with a fight. And also, let me tell you, they've actually made the life of lawyers very easy. You don't need a great understanding of law to challenge, a notification like this. It is done exactly in the way. Finally, if you give me just 1 minute more, I'll just tell you, when we challenged the amendment that they brought out in the building and construction provisions 3 years back, what the government said? They said that the building and construction sector is the single biggest contribution to greenhouse gas emission, right? That's the biggest contribution. It is one of the most polluting sectors. And therefore, in order to make all buildings and construction projects climate resilient, in order to meet the requirement of Paris Agreement, we have decided to take building and construction outside the purview of EIA notification, Air Act and Water Act. We went to the NGT and said, very simple, if you regard Water Act, Air Act and EIA law as the main reason why Indian construction sector is not in compliance with Paris Agreement, please apply it to all sectors. And most importantly, please do away with the NGT also, because the NGT has been set up to implement the 3 laws. If you don't do it, and the only thing that comes in the way of India becoming climate resilient is the EIA, the NGT Act, the Air Act and Water Act. We succeeded, and we are very confident that if they follow the same trend, this is not going to stand any kind of judicial scrutiny. But most important, I think before judicial scrutiny, this law has failed the public itself. The public have rejected at large this litigation, this new legislation.
Thank you so much for sharing your views, sir. That gives a lot of confidence, I think, to everybody, knowing that hopefully this should not see the light of day, at least in its present form, unless it is changed or something, as many of our speakers also indicated, perhaps a whole different comprehensive policy that does comprehensive assessment is actually the need of the hour, and one which may be better legislated rather than given to subordinate legislation, where everything is deliberated and people are included in the consultation process before it's brought in. Before we move to the speakers, I see that Dr. Reddy would like to say something. I would like to invite Dr. Nagendran Murthy, if you're there, sir, if you would like to comment on anything before we move to the speakers. Dr. Nagendran, are you able to hear us, sir? Okay, perhaps he's unable. Wait, my apologies. He may not be able to unmute himself. That would be my fault. Sir, are you able to unmute yourself now? Okay. In the meantime, Dr. Reddy, would you like to give us your comments or questions, sir?
I have three inputs to make. One, I'm getting increasingly uncomfortable with this discussion only on EIA. Not because of the current discussion, but our experience last 30 years, we have been fighting a lot of projects. And ultimately, we are discussing EIA 2020 as the demo. But even the previous process was also has not facilitated any way where environment can be protected, because we know we have several examples. So I feel the EIA process is a kind of bureaucratization of ecology and environment. So that limitation is there, and I think we should get out of that limitation and start questioning the larger process. There I have two examples to give you. One, we are talking of a Hyderabad pharma city near Hyderabad, which is supposed to come up as a cluster of pharma industries. But even now, before that pharma city comes, around Hyderabad in a 150-kilometer area, there are a lot of pharma industries, and 2/3 of pharma production happens in Hyderabad, and export, I think even the export almost 40% goes from this place. And addiction is very deep and intensive and irreversible. Now, when we are questioning that, the EAC process, they look at only what is written by the project proponent. They are not looking at this larger picture where there are already pharma industries, and they say it is not the part of their mandate. So where do we go and discuss this? And second example I would like to give is 2 years back, there was this photo in a newspaper where women in Adilabad, they are walking through vehicles full of cotton loaded, and that vehicles are going to the local cotton market. And these women are going to collect free saris given by the government of Telangana. And these saris are polyester made. The Adilabad produces cotton, and those women, they can't use that cotton. But in the process of production, their children, they don't have, they have anemia. If you look at 14-15% of anemia, then pesticide pollution, a lot of issues, and they don't have food. They depend on PDS, and then they depend on the government doles, and which again we think is entitlement coming to them. So their independent life we've lost because of this system which we brought in the last 10-15 years. So my question is, when we are talking of environment and development, where do we bring these issues apart from the EIA process? I think that even Dunura is also asking us.
Can I say something? Can I?
Yes, sir, please go ahead.
I would, I mean, he's raised an important point. Mr. Reddy has said that besides the project clearances based on an EIA, why shouldn't we go into the aspect of EIA in the product itself also? I mean, add on that why can't we factor in the product that is going to be given out by that particular industry that is going to be set up? It has not been done. Like in particular case of fiber, he mentioned that how it is going to affect the lives of people, or how it is going to affect so many other things. So likewise, I'll give you an example for fisheries. I mean, if you take up a project for fisheries, if a mega project for fisheries of artificial rearing of fish feeds, fingerlings is taken up, then what is the outcome? You will be introducing exotic carp fishes which have a very high productive value and which are sold at a very high price in the market. It will be at the cost of losing the indigenous fishes. So these kind of aspects have to be looked into while we decide upon the EIA. As I think Mr. Nair made a very important thing, that by he said it should be completely scrapped. And we have to institutionalize the system. We have to bring out a totally new structure for the process. It would be much better than we can come out with our own format and a proposal to the government that it could be done like this. That's what my point was. Thank you.
Thank you, sir. We are over time, and I'm very sorry for that, but we did commit to take questions from our participants. Due to the paucity of time, if it's all right, we will take only 2 questions from our participants at the moment, and we would be happy to engage with you after the session through our website. So if there are any participant questions to the panelists, I request you to kindly raise your hand and we will recognize you. And it's a sincere request to we will try to wrap up in the next 5 to 6 minutes. I apologize for the extension. Are there any questions from the participants? Or alternatively,
Ruchitra,
if the panel...
There is one,
sorry.
There is one Ruchitra. Yeah, she has raised a question. No, there was a message in ask her.
I don't see a raised hand though.
Ruchitra.
Yes.
Yeah.
The chat box.
Please go ahead.
There are some questions.
Ruchira, please go ahead and ask your question. Maybe I need to unmute you. There are 2. Are you unmuted?
Hello.
Yes, please go ahead.
Yes, I have already sent the question for Prerna. I had sent it over email, but right now a lot of other questions are coming up. That is the area you're talking about. How is that area under political, what's the political climate over there? If I could get some idea about it as a remote thinker or seeing from somewhere else kind of a thing. Like if I could understand where you are, why is it ecologically impossible, or why is it ecologically not possible to do this? It's like if I could say it for a layman, try all the panelists, what is their total judgment on this EIA as of now? And when was it released? I hardly think people know about EIA, like in the public sphere. So I really think about the public sphere a lot. So yeah, I would really like you to tell me why is it ecologically impossible to have the EIA, and what is the political climate over there?
Ruchira, thank you for your question. I'm afraid that the question, because it may be a little wide, so that may require a lot of time to answer.
But perhaps about Hyderabad and Pharma City, so I thought they could elaborate on that.
Perhaps it's all right to take this up on a different channel if you permit. We can take it on the website instead of right now, because we're unfortunately well over time, and I would not like to keep participants. So I apologize. In the interest of time, I think I'll begin wrapping up. We're sorry that we couldn't engage the panelists and the participants in a larger dialogue. These are some of the issues that we do face with technology and with this format. But so please excuse us. And I would now proceed to closing the discussion. I extend my deepest gratitude to all our speakers for taking out time to be here for today's dialogue. I also want to put on record my appreciation for the entire Mandate Project research and media teams which have been working tirelessly behind the scenes. This discussion is not an end in itself, it's part of a larger consultation program. And towards this consultation program, we have certain research outputs, including the primer, which we circulated before the discussion for all the panelists and for the benefit of our participants. We are also coming up with a comprehensive report, which will be completed shortly and circulated with everyone. Special thanks also goes to Dr. L. Pushpa Kumar for guiding us through this entire project, and to Mr. Avikrish Bedi for ensuring the session proceeded smoothly. What we've tried to do here today is very ambitious, and we can see because we have overflowed on the time, the scale of how ambitious it was. But I hope everyone will see what was intended. The intention here was to bring together all the various voices, as Ruchira and as others have pointed in the chat box, that we are all civil society. We are all experts in our specific domains. But when it comes to things that don't respect expertise, borders, boundaries, even species, which is, for instance, damage to the environment, we have to be allies in the cause together. As I've already stated, because of the paucity of time, we could not take everyone's questions. I recognize that we have a lot of participants, distinguished participants amongst us, and we will be happy to engage with you on a different platform. If you allow us to do so, we would invite you onto the website, or you can contact us through email. We will work with you. Professor Pushpa Kumar and I will reach out to all of you. And as I said, today's event is part of a larger project, not only for the EIA, but to involve everyone in the process of understanding complex issues and becoming active stakeholders in the decision-making process. So discussion is just one part of the story. And we invite you to collaborate with all of us, as we would like to do with all of you. We are sharing a link to a survey in the chat box for you to express your opinion on the draft EIA notification 2020. We request you to kindly take out time to fill it. Your inputs will be included in our final submission, which we will make to the Ministry of Environment by the 11th of August. I apologize for racing through towards the end because we have overshot our time. And I thank everyone for being here. I will just copy the link and we will share this with everyone in a follow-up email along with our documents that we have prepared to submit to the ministry. I have shared the link now. If you have any queries, please reach out to us through email or through our social media handles. And I thank everyone once again. My apologies for just summing everything up quickly towards the end. Have a great evening and a good week ahead. Thank you, everyone.
Thank you.
Goodbye.
Thank you very much.
Thank you very much.
Thank you.
Thank you to all our panelists. Thank you for being here and thank you for being so patient.
Thanks a lot.
Thank you. Thanks.
Thank you.